Well, this was a decision by the Israeli Supreme Court, sitting for the first time ever in its full panel of 15 justices, signifying the importance of the case. And it dealt with the constitutionality of an amendment passed by the Knesset a few months ago to basic law to judiciary, which is one of the basic laws Israel has. It regulates its constitutional matters. As we know, Israel does not have a formal constitution, but it has a series of basic laws it has enacted over the years, and they include material that look a lot like chapters in the constitution. Around the mid-1990s, Israeli law has decided to take these basic laws as having constitutional power, in the sense that they're supreme to regular pieces of legislation passed by the Knesset. And indeed, the court has used its power of judicial review to strike down regular laws when they violated norms included in the basic laws. What's unique about the basic laws is that they are enacted in the same process and with the same majority as any other regular law by the Knesset, which means that basically any regular majority in the Knesset, governed normally by a coalition government, can pass regular laws just as it can pass basic laws. The judicial overhaul proposed by the government a year ago, in January 2023, included proposals for amending all different elements of Israel's basic laws in ways that would all come to limit or curb the power of the courts, the Supreme Courts, legal advisors, and civil servants, and on the other hand, empower the political branches, namely the government, and its control over Knesset. The law at hand was one of these measures, basically the main piece of legislation the government managed to pass, given all the opposition that was in Israel. And that was an amendment that said that no court in Israel, including the Israel Supreme Court, can review acts of the government, prime minister, or ministers for unreasonableness. The reasonableness doctrine is a familiar doctrine from common law, has developed over the years in Israel as well. And some argue that since, say, the 80s or 90s, has enabled the court to apply more sort of discretionary analysis to administrative decisions, granting it more power than before. And the government sort of pushed that argument to try and argue that the court should be limited again and have less power of reviewing administrative actions. So this was a sort of a signature part of the judicial overhaul plan by the government. It was also, some people saw as necessary for the government's specific goals within the judicial overhaul plan. So for example, another element of the plan was to change the judicial appointment process, and the justice minister who runs that process did not want to convene the appointments commission until he manages to get his wishes. Such a decision not to convene that commission would be subject to reasonableness review. And once you take that off the table, you basically empower the minister to push forward his reforms. So that's just one example. This was tied into also the specific purposes of the reform, even beyond kind of the general question of the relations between the branches. The case comes to court, and basically we have three main legal questions that the court has to decide. The first one is a sort of meta-constitutional question. Does the Knesset, when it enacts basic laws, so when it uses its power to amend or enact new basic laws, is it limited in any sense, or can it do whatever it wants there? The question is intriguing because in one sense, these are constitutional amendments because they have the level of constitutional power. And normally constituent assemblies are considered unlimited in the content they can include in constitutions. On the other hand, the body that enacts these amendments in Israel is the same Knesset with the same regular majority, basically applying its normal politics to the matter. So is it limited at all? Second question, if the Knesset is limited, is the court empowered or authorized to strike down basic laws that surpass these limitations or violate them in any way? So this is a question about the jurisdiction of the court. Third question is, even if the court is authorized to strike down basic law legislation, whether this specific reasonableness amendment should be struck down. So we had three different legal questions here, and the justices came out differently on these questions. So we don't have a single split majority-minority decision, but we have several answers or varying answers by different justices in the court, and we'll discuss these shortly. So the court decided to strike down the reasonableness amendment, which tells us basically that it did get a majority to answer positively to all three questions, right? We had a majority in the court that said, first of all, yes, the Knesset is limited even when it enacts basic laws. Second, the court is authorized to enforce those limitations by striking down basic law amendments. And third, the reasonableness amendment violates these limitations and therefore should be struck down. The first two determinations, which are kind of the meta-constitutional ones, were decided by a very large majority on the court. Depends on how you count. It's either 12 against 3 or 13 against 2. There was one justice who sort of swayed between the two positions. But we had a broad majority supporting both propositions. One, that the Knesset is not omnipotent when it enacts basic laws. And the second is that given these limitations, these are legal limitations that should be legally enforceable, and the Israel Supreme Court, sitting as a High Court of Justice, is the most appropriate body to enforce these limitations. The main reasoning provided by the majority of the justices to these decisions is that Israel is just a unique and problematic case. Yes, it does have basic laws that look a lot like chapters in the Constitution, and indeed it enjoys supremacy over all other acts of government and other enactments of the Knesset. However, we have to face the reality that these basic laws are enacted in a normal legislation process, which basically means, given Israeli coalition politics, that the government has full control over majority votes in Knesset, including amendments of the Constitution. Now, this is problematic in theory, and it also doesn't sit well with the idea of constitutionalism as a legal means of limiting governmental power. Here, basically, if you say the government who controls a majority in Knesset can basically amend the Constitution however it wants, that could imply basically an unlimited government, which is kind of the opposite of the democratic idea. Now, we knew this early on, and Israeli constitutional law has been living with this sort of paradox for years. Thankfully, most coalition governments over the years did not severely abuse that power. And indeed, when we got basic law amendments in the past, they were usually either not very kind of problematic in terms of, sort of ideologically or ethically, and also often garnering broad support from both coalition and opposition parties. Over the past few years, these norms, these unofficial norms of constitution making have deteriorated in Israel. And we saw once and time and again, coalition governments basically using their simple majority in Knesset to amend constitutional norms as well. And the court has noticed that and said, this is a new reality. We have to face that. Somehow, informal norms can no longer work, and there should be some legal enforcement of this distinction between regular laws and basic laws. You can't just put anything you want in basic laws. And the majority said, so what are these limitations? Where do we find them? What do we tell the Knesset, this you cannot do in basic law? Different justices varied in how they explained their reasoning here, but the general agreement was that Israeli constitutional law, even without a constitution, does have some core values that have shaped the development of Israeli law throughout the years, law, institutions, and political practices. In the words of Chief Justice Esther Chayut, she says these are basically the concepts derived from the idea of Israel as a Jewish and democratic state. And if the Knesset uses its power to enact basic laws, so constitutional statutes, that severely violate the norms that are inherent in the definition of Israel as a Jewish and or democratic state, so either a combination or each one of these two concepts, then the court might say that it has surpassed its constituent power, basically, and might strike down those norms. This is not the first time the court has dealt with these questions. Previously, you might recall Basic Law, Israel, the nation state of the Jewish people, which has also garnered much dissent and criticism in Israel, also came before the court. Already the court there considered the issue of whether such a basic law could violate Israel as a democratic state, for example. because it sort of implies a distinction between Jews and non-Jews within Israel. And the court said, we can interpret that basic law in a way that would not sort of violate those basic values, and therefore kept it be. But now arrives the case of the reasonableness amendment, and here we see smaller majority. So if we had 12 or 13 justices saying yes, the Knesset is limited, and it's limited by the notion of Israel as a Jewish democratic state, only 8 of the justices, so a single vote, 8 against 7, said, and the reasonableness amendment in fact violates the norms of Israeli democracy to such an extent that it cannot stand. So 8 justices say, given the way Israeli law has developed over the years, the reasonableness doctrine has taken a very significant, very important role in protecting the legality of the executive in Israel. For example, Israeli law has very few norms that pertain to the appointment and dismissal of high-ranking civil servants. And the concern was that if you take away reasonableness, which was basically the main norm applied to those issues, the government could then push through plans it actually stated it has to, for example, retire the attorney general who's been who's been in charge of the trial against Netanyahu, or against the prime minister, or replacing the chief of police, or the chief of the IDF, just using its own power. And the court says, like it or not, reasonableness has been a significant element in the structure of our government to maintain this independence of our professional bodies. Therefore, it cannot just be thrown away without kind of a better structure put in place. So we have a majority of justices agreeing on that and saying, this cannot stand. Within the minority, several of the justices, so 3 of them said, this is a question of interpretation. The amendment can be interpreted in a limited way that would limit the severity of its harm to democratic principles of rule of law and separation of powers. And it is we are required, we the justices are required to do whatever we can in order to, not to arrive at a striking down of a statute, and therefore we will propose a kind of limited understanding of that statute to allow it to stay in force in a way that will be kind of acceptable in constitutional conditions. So basically, we have a large group of justices, the 8 in the majority, but another 3 in the minority, who were quite critical of the legislation as it passed. 8 said, this just cannot stand. 3 others said, we will not strike it down, but we will interpret it down to a more limited capacity to allow some power of review to still remain with the courts. The small minority, complete minority in dissent, the 2 justices, are basically saying, Israel does not have a constitution. The court cannot come up with one. And therefore, as long as there is no formal authorization of the court to review basic laws, we just have no power to do so. And basically staying in a small minority, saying, the Knesset is unlimited in Israel. Well, I guess we can make a few possible connections between this case that began before, obviously, the horrific events of October 7th and the era we are in now, whose end is not yet in sight, so it's kind of difficult to even know where this is going broadly. First of all, start from kind of a relatively minor aspect. There was a question that became a relatively hot political topic of whether the court should at all publish its opinion during this ongoing war. You might know that there was also a leak of the draft opinion about a week before it was formally published, kind of reminding us of what happened in the US with the abortion decision. And some people thought that this was an attempt to sort of pressure the court to wait with the publication of the decision and not introduce back into the public forum in Israel the question of judicial overhaul when everybody is engaged in in the issues of the war. The court still decided yes to come out with an opinion now. Formally, it had to because two of the justices are about to retire and had to finish writing their opinions by mid-January. And some attempts to keep them on or such other moves were rejected. So if there was a sense that since October 7, all eyes are now on the issues of the war, and no one any longer discusses judicial overall, the fact that the case came down obviously brought this back to the fore. While the government has not responded severely to the decision, the Justice Minister has not welcomed it and has said, when things calm down again, and we will take that into account. A second aspect one could mention, and this is an argument that came up during the opposition to the judicial overhaul already before, is that when you look at Israel from outside and try to evaluate the degree of its commitment to concepts such as the rule of law, issues that are now very pertinent to the way Israel is waging its war, then one of the arguments made was that a strong and independent Supreme Court with powers to review decisions of the executive is actually an important element of projecting Israel as a state committed to the rule of law, even under emergency conditions like the war. In that sense, coming out now with a decision, and I can also, I will assume that at least some of the justices thought that this is an obligation they have to the country to come out even now while Israel is being criticized severely about its commitment to the rule of law and the way it wages the war, to come out and say, no, there is an independent court here, and there is a reasonableness doctrine that allows the court to review executive action, which to some degree can also pertain to actions that have to do with security measures or waging the war. A third, and obviously, just tomorrow, the ICJ is going to start hearing the South African case against Israel when it comes to the Genocide Convention, and it's noteworthy that Israel, as a party to the case, had the right to appoint one justice to the ICJ panel, and the justice they chose to appoint was Aharon Barak, the former Chief Justice, who has been lambasted and criticized by the government itself throughout its attempt to push for the judicial overhaul, kind of saying, he was the one to blame for all bad things, and we're just trying to curb his effect or the impact he had on the court, including the reasonableness doctrine, which he was one of its most proponents. And now that very same government is asking Aharon Barak to be our face in the court. So we see the irony in that. In the sense, it all ties into kind of the same week of both events. One third point to make, and in more say critical sense towards the court, is that like other courts around the world, I'd say, so other Supreme or constitutional courts, the court seems more comfortable in being activist when it comes to questions of separation of powers or its own capacity to review acts of government. It is a less sure when it comes to sort of questions of human rights that involve kind of competing ideologies. I already mentioned the court's unwillingness to, for example, review the basic law, the nation state of the Jewish people, which invoked several sort of complex questions of rights. And now, during the war, we see several decisions that have been quite criticized by some circles. For example, allowing the government to significantly curb the freedom to demonstrate against the war in Israel. It has been unwilling to review rights of detainees issues post the war. So we see some, if you will, dissonance between its quite activist move in the field of kind of constitutional structure questions, as opposed to its being very careful in reviewing decisions of the government that pertain directly to kind of the context of the war. And we still need to see where this is going to go. Well, obviously, to some extent, this is an open question. Right now, just a few days after the war began, one of the centrist parties from the opposition joined the government in an emergency war cabinet. And part of the agreement there was that no unagreed upon moves were going to be made. And that basically sort of put a kind of a stopgap on the judicial overhaul. And indeed, we saw that after the court came down with this momentous opinion, by the way, 740 pages long. The court comes down with this momentous opinion. The government basically does not respond, and you know, we had a few extremist Knesset members who came out against it, but the government overall has been relatively subdued in its reaction. This might be just thanks to a decision not to deal with those issues during the war, and things will come up again in the future. Or kind of a more general understanding, which is what we would hope, is that Israel has to rethink its social connections, and the polarization has been just too extreme. And hopefully the government now realizes that as well, given just the horrific trauma of October 7th and the ensuing war. One thing to note, however, is that several, say, complicated cases that have been pending before the court, we're waiting for this decision to come down. So, for example, we have a couple of petitions against the ultra-right Minister of National Security in Israel, Itamar Ben-Gvir, including the reasonableness of his appointment as minister, given his previous convictions in terror-related offenses and whatnot. Several other petitions against decisions he's already taken as a Minister of National Security. And these cases have basically been waiting for the reasonableness decision to be made, because now reasonableness is back on the table and it can be used to review both his appointment and his decisions. Basically, the opinion about reasonableness does not require an immediate decision by the court, by the government, whether to comply or not, because there is no specific issue on the table. But once these decisions are made, for example, about the Minister of National Security, then the government will have to make a specific decision whether to comply or not, whether to let him keep his job or stay in office if the court decides to eliminate that appointment, or whether to or how to treat other decisions the court will take against him based on reasonableness. So that's still an open question, and there is a concern that at that point the government might say, you know, we're not taking seriously the decision of the court, and we're just going to wait to replace a few of the justices in the next few appointments, and we will bring this back into the picture. So basically, we need to keep following that. This could be an issue within the next few weeks or months, because a few petitions are about to be decided based on the reasonableness document that has now been revived.